Bondi at the podium. Representing a coalition of states in a major federalism case, Bondi had entered the courtroom facing widespread skepticism. She wasn't a frequent face before the court, and some questioned whether the former Florida Attorney General was prepared for such high-level constitutional litigation. Barrett didn't wait long. "Miss Bondi," she said, her voice cutting through the silence, "your argument contradicts established precedent in at least 3 major decisions. I suggest you revisit Harrington versus Davis before presenting such theories to this court." It wasn't just the substance, it was the tone. Dismissive. Direct. From a justice known for restraint, the challenge was unexpected. Bondi paused briefly, betraying no emotion. "Thank you, Justice Barrett," she responded calmly. "I'm familiar with Harrington, and if permitted, I'll explain why it actually supports our position." Barrett raised an eyebrow. "Go ahead." Bondi didn't check her notes. Harrington limited federal power when state sovereignty remains a compelling concern. Justice Kavanaugh's concurrence there introduced a 3-part test, one that the current regulations fail, particularly the requirement that federal actions minimize administrative burdens on states. Justices shifted in their seats. Bondi cited Westmoreland versus United States, a lesser-known case, then pointed out that it had been referenced by the court in Montgomery versus Louisiana, a footnote most had overlooked. Even Barrett's expression changed, less skeptical, more curious. She posed another question, this time about Article 3 jurisdiction. Bondi responded with a nuanced reading of Nick versus Township of Scott, connecting federalism limits across precedents. What began as a confrontation was turning into something far more significant, a constitutional exchange between 2 formidable legal minds. The atmosphere inside the courtroom had shifted. What started as a tense exchange had become a riveting display of constitutional reasoning. Justice Barrett, initially on the offensive, now leaned in, not to challenge, but to understand. To test Bondi's legal depth, Barrett offered a complex hypothetical involving overlapping federal and state regulations. Observers expected the scenario to finally reveal Bondi's limits. Instead, Bondi didn't flinch. "That's an excellent hypothetical, Justice Barrett," she said smoothly. "It highlights the exact constitutional tension we're here to resolve." She then dissected the scenario with methodical clarity, identifying 3 guiding principles rooted in precedent, citing opinions not only from the court but from Barrett's own earlier rulings on the Seventh Circuit. In your 2018 opinion in Wisconsin Manufacturing Association, v. EPA, Bondi noted, you argued that when regulatory frameworks conflict, courts must determine which sovereign holds primary constitutional authority. That reasoning, I believe, provides the path forward in your hypothetical. Barrett blinked, clearly surprised, not only by Bondi's knowledge of her past opinions, but by the deft application of her own legal philosophy to the current case. Justice Kagan interjected, raising a potential flaw. "Miss Bondi, doesn't Friedman limit the scope of that argument?" Without missing a beat, Bondi replied, "Justice Kagan, Friedman addressed interstate commerce, not the commandeering of state administrative structures, which is central to our case. In fact, the Friedman majority explicitly excluded scenarios like ours from its holding." Kagan gave a subtle nod, impressed. As Bondi continued, she mapped out the evolution of federalism doctrine, connecting obscure concurrences and overlooked footnotes with precision. The court was now fully engaged. Justice Alito raised a follow-up. Justice Thomas scribbled notes. Then Barrett asked something unexpected. "Miss Bondi, if we accept your framework, how do we articulate a limiting principle to avoid misuse in future cases?" The question marked a dramatic shift, from testing to trusting. Bondi answered by outlining a balanced, 3-part test to guide future courts, protecting both federal interest and state sovereignty. By the time the Chief Justice signaled Bondi's time was up, the entire courtroom was silent, hanging on her final words. Then something rare happened. Justice Barrett requested additional time so Bondi could finish. The challenge had become respect. As Pam Bondi returned to her seat, the courtroom buzzed with quiet awe. Justices whispered to clerks. Law professors in the gallery exchanged looks of stunned respect. A moment meant to test her had become one of the most riveting constitutional arguments in recent Supreme Court history. The Solicitor General, who was set to argue next for the federal government, was seen furiously scribbling notes, clearly recalibrating in real time. Bondi had just shifted the momentum of a case many believed was already decided. Inside the court's private conference room days later, the justices gathered to discuss the case. According to insiders, Justice Barrett broke with her usual reserved style and addressed the room directly. "I believe we witnessed an extraordinary display of constitutional advocacy," she said. "Ms. Bondi's analysis, particularly her proposed framework, deserves serious consideration." When the court's opinion was released 3 months later, the legal world took a collective breath. The states had prevailed. In a 6-3 decision, the majority adopted substantial portions of Bondi's proposed framework for analyzing federal overreach. Justice Gorsuch authored the opinion, but in a remarkable move, Barrett wrote a concurring opinion specifically engaging with Bondi's arguments, including a citation to one of Barrett's own earlier rulings, reinterpreted through Bondi's analysis. Constitutional scholars were stunned. The new 3-part test for evaluating federal regulations, quickly dubbed the Bondi test, was now part of federalism jurisprudence. Law schools began teaching the case in constitutional law courses. Legal blogs called it a masterclass in advocacy. A prominent liberal scholar tweeted, "Whatever your politics, Bondi rewrote the rules today." 6 months later, Barrett and Bondi appeared on the same panel at a Federalist Society event. While they avoided discussing the case directly, their mutual respect was evident. Barrett offered a reflection, "Some of the most meaningful moments on the bench come when our assumptions are challenged by advocates we did not expect." Bondi replied, "Our system depends on ideas being tested, not where they come from. That's how doctrine evolves." In legal circles, a new phrase entered the lexicon: pulling a Bondi, used when an underestimated advocate delivers a performance that changes everything. The case was over, but its impact was just beginning.